Hi, welcome to lecture number 6. The title of this lecture is Dental Liability Risk Management. And liability risk management means different things to different people. So to a medical malpractice insurance executive, risk management probably is a cost containment tool. In that instance, the objective to risk management would be to reduce the number of claims being filed and reduce defense costs associated with claims that are filed, which include indemnity payments, lawyers, expert and court fees, and other costs associated with defending a claim. I approach liability risk management from a patient safety standpoint. So in my opinion, the goal of risk management should be patient safety and patient satisfaction. Why? Because unexpected outcomes, for example, patient injuries, are the main reason the patients sue their healthcare providers. But patient injuries are inevitable, and some patients are unusually litigious, which means that some lawsuits are bound to be filed even with the best patient safety and customer satisfaction protocols. Therefore, it's important to have excellent documentation, informed consent, adverse event, difficult patient, and conflict management protocols in place. I'll cover all of these in this lecture. You'll want to choose an insurer with on-call risk management. This usually comes as an advice line that you can call. If you have a bad feeling about something or are worried that something is going to lead to liability, or you can't figure out what to do with a difficult patient, or you get a malpractice complaint served on you, you can always call your insurance risk manager for advice. Remember, your insurer does not want you to be sued. They will be happy when you use their resources. National data indicates that the most common dental malpractice claims include delayed diagnosis and treatment of infection, delayed diagnosis and treatment of periodontal disease, procedures performed on the incorrect tooth, paresthesia secondary to third molar extraction, and TMD surgical malpractice. So, why do patients sue? Any patient can become a malpractice plaintiff with sufficient motivation. Some of the most common reasons for filing a lawsuit include dissatisfaction with the result of treatment, which may be the result of unrealistic patient expectations and/or which may be the result of an ineffective informed consent process. Some patients sue because of money. Something unexpected has occurred and they don't think they should have to pay for it. Some lawsuits are filed because of misunderstandings between the patient and dentist, because a patient is angry, frustrated, or just generally litigious. And then a lot of claims are filed because a subsequent treating dentist criticized the care of a prior dentist. When these issues arise, skillfully communicating with the patient is critical. Don't procrastinate with implementing patient safety and risk management policies and procedures. There is no going back once a lawsuit is filed. The key is to keep the lawsuit from occurring. Give patients the information they need on a website and provide the website URL on all of your patient communications. This is a way to set the stage for communication with your patients. The information on your website can vary. You might include things like short biographies of you and your staff members, basic services provided by the practice, office address and hours of operation, phone numbers, including main number and an appointment line if they're different, instructions regarding after-hour care and prescription refills, when to call for an appointment and when to go to the emergency room, patients' rights and responsibilities, including missed appointments, tardiness, and billing, some basic rules of behavior, including child supervision in the reception area, and also guidelines addressing the use of email for communicating with the dentist and staff, including expected response times. You want to provide an excellent patient experience. In doing so, you want to make sure that your staff is creating a good impression with patients. They should be using good telephone manners. They should appropriately greet patients when they arrive. They should use discretion and confidentiality while discussing health or financial information. They should get patient telephone messages to you in a timely manner. They should provide excellent appointment triage and patient scheduling. They should be respectful towards patients. They should respond appropriately to patient dissatisfaction and report it pursuant to established protocols. And they should create a favorable last impression. Staff members who cannot maintain good attitudes with patients should not deal directly with patients. A dentist with good chairside manner is less likely to be sued. You need to provide an excellent patient experience as well. Even if it takes a little longer to provide treatment, try hard to establish a decent relationship with the patient. Elicit, listen to, and respond to the patient's questions and concerns. If a suit is filed, good patient rapport is always beneficial and can lessen damages and keep litigation from becoming ugly. Even if quality care is delivered, if a patient has to wait 45 minutes for every appointment, never gets an apology, and the staff is brusque and unfriendly, that patient might become angry at the dentist or the group and file a lawsuit. Don't criticize your colleagues. Before you start criticizing a prior dentist's care, stop and think. How many times have you had a patient in your practice who simply wouldn't follow your treatment plan, or didn't keep their appointments, or wanted to piecemeal their treatment, or left and went to another practitioner without telling you? Do you ever worry about what a subsequent treating dentist will think of your care? If you are critical of another dentist and your patient does file a lawsuit, keep in mind that that patient will want you to provide expert testimony in support of his or her lawsuit. Being critical of a colleague in the privacy of your own operatory is one thing, but are you ready and willing to provide your opinions in public? If you're not willing to stand behind and support your opinions in court, I personally don't think it's fair to the patient to be critical in private. You always want to avoid allegations of patient abandonment. Abandonment can be an issue when you terminate the patient relationship, close a practice, or move from one practice to another. If you are leaving your practice and there is no one in the practice to take over patient care, take the following precautions. 1. Send a letter to any patient who has been an active patient within the past 2 years. Your insurer may have different ideas, so follow what your insurer guidelines are. You want to send a follow-up note with the invoices, for example. Inform patients of your last day of practice and the last date you will be available for emergencies. Do this at least 60 days prior to your last day at the office. With the notification letter, include an authorization to have their records released to another dentist. Give the name, address, and phone number of where patients can obtain copies of their dental records. Consider posting an ad in the local newspaper for 2 weeks with information about the location of dental records. You might want to refer patients to a couple of new dentists or the local dental society or to a dental referral organization or online service. Also, only begin treatments when you know that you're leaving that can be completed before the termination date. Your liability insurer should have sample letters for you to use in various patient termination situations. Everybody is going to have a difficult patient now and then. I can't tell you how many times I've gone through a claims file and discovered a difficult patient who turned into a plaintiff in a lawsuit. Some red flags that you may notice, which are not necessarily something that you need to dismiss a patient for, include a patient who is using a lot of dental terminology, a patient who is seeing multiple dentists or dentist shopping, a patient who's been terminated by previous dentists, or patients who want temporary treatment or pain medication. A patient who's taking notes or keeping diary can be troublesome. Patients who dictate care, who want care that you don't provide, or who want special accommodations, for example, after-hour appointments, special billing arrangements, etc. These are people who can become problem patients who may need to be dismissed. Pay attention when something doesn't feel right. You want to define inappropriate behavior to staff so that everybody understands what's acceptable and unacceptable. Everybody needs to be on the same page in your office. You want to have a difficult patient plan. Once a patient has created a problem, you need to decide whether this is a patient you would like to rehabilitate or terminate from care. Termination is more likely to lead to liability, but do not sacrifice everyone's safety and well-being to avoid a lawsuit. You want to intervene early and not let the problem escalate. If you choose to rehabilitate the patient, a point person should meet with the patient and explain the practice's expectations. Here are some guidelines for that meeting. First, you want to clearly identify the inappropriate behavior or actions. Second, explain why the behavior is not acceptable. Third, listen carefully to the patient's response to identify any unresolved or previously unidentified issues. Fourth, describe and document your expectations of the patient. Fifth, document the patient's acceptance or rejection of your expectations. Sixth, communicate these expectations to your staff so that everybody is on the same page regarding this patient. 7, consider limiting the patient's staff contact to a designated point person to ensure compliance. 8, create a patient contract or dental treatment plan that memorializes the patient agreement. If you do choose to make a patient contract, the contract should identify the consequences, such as termination of care for breaching the terms. You want to have the patient sign and date the patient contract, then give the patient a copy and place the original in the chart. Reasons for dismissing patients. The unilateral discharge of a patient without sufficient notice or notification of alternative sources of care is grounds for an abandonment claim or a complaint to the local or state dental society. Generally, you may terminate your relationship with a patient at any time and for any reason. However, you may not discharge certain patients without first making arrangements for someone else to provide care for them. You also cannot discharge a patient for discriminatory reasons. For example, because of race, religion, national origin, disability, age, sex, or any other protected socioeconomic status. When you are dismissing a patient, you want to do a number of specific things, and these things should be in a protocol. You want to send a letter setting the date of termination at 30 days from the date of the letter and inform the patient that emergent care will be provided for the next 30 days. You'll send the letter by regular and certified mail with return receipt requested and file a copy of the letter in the chart. You also want to refer the patient to other dentists via a dentist referral service. There are a lot of dental referral services online, so you can list a few in your letter, but you want to check them out first, okay, to make sure they're legitimate and that they're helpful. Also, offer to provide a copy of the patient's dental records to the new dentist that the patient chooses. You do not need to indicate in the letter why you are terminating care, but you do need to indicate why in the chart notes. If a patient has been dismissed, don't take them back. That's very important. If you keep taking the patient back again and again and again, there's no real dismissal of the patient, and you're looking at a lawsuit probably. Everybody's going to have to deal with some adverse outcomes in their future dental practice. Adverse outcomes are usually not the result of substandard care, but instead are known risks of the procedure. A really good informed consent process and ongoing effective communication can divert a lawsuit by distinguishing a medical error and a known risk of the procedure. How the dentist responds to an adverse outcome, even when caused by medical error, has a huge effect on a patient's decision to file a lawsuit. Research indicates that a well-thought-out apology can reduce the risk of liability following an adverse outcome. Some states have legislation that keeps statements of apology out of evidence in malpractice actions. The laws vary a great deal. Unfortunately, there are no apology laws in the state of Minnesota. You want to pay attention to Karen Quick's advice about conflict resolution. There are strategies you can use to contain the potential damage of a conflict with a patient. For example, if a patient is complaining about how long it's taking for an infection to heal, try saying something like, you sound upset about the slow healing of your infection. Let the patient talk. If it is clear the patient has a valid concern, acknowledge it. The facts are the facts. You run a business. You deserve to be paid, but you will have to treat collections differently than other business owners because of professional liability risk. Unfortunately, some malpractice claims are filed in retaliation for collections actions. Also, patients sometimes view their dental treatment in contract terms. They believe they contracted for a special outcome and didn't get it. Therefore, they feel they should not have to pay for it or should only have to pay for some of it. You might want to analogize this to hiring a roofing company to replace your roof. They put the wrong color shingles on, or the shingles are not lined up correctly and look bad, or they put new shingles on without replacing the rotting boards beneath the shingles. Are you going to want to pay the roofing company? Probably not. That's how your patient might feel about an adverse outcome. It's important to find out why the patient isn't paying before sending the issue to collections. You could be asking for a lawsuit if the patient is dissatisfied. Sometimes you need to weigh the amount of money involved against the risk of the malpractice claim. I advise against setting up a system in which unpaid dental bills are automatically sent to collections without your express consent. What to do if you're sued. As soon as you receive the summons and complaint or a patient threatens to sue you, report it to your malpractice carrier. You want to make copies of the legal papers and send the originals to your carrier. Write a summary of the treatment of the patient, including everything, even if it's not in the treatment notes. Do not put this in the patient file. You want to start a separate litigation file. Send a copy of your summary of the patient care to your insurer, and you want to tell your staff about the lawsuit, but instruct them not to talk to anybody about it. Anything that your staff or you say to other people about the facts of the lawsuit can be discovered in litigation, but the things that you say to your insurer or to your attorney cannot. They are protected. These are things that you should not do if you are sued. Ignoring a lawsuit is not going to make it go away. Attorneys don't forget that they have filed a lawsuit against you. If you ignore a lawsuit for long enough, for example, 30 days usually, the plaintiff can get a default against you for the entire amount of damages she claims she suffered. Also, you will have some sort of requirement to report to your malpractice insurer. Don't offer to pay the patient money to make the lawsuit go away, and don't enter into negotiations with the plaintiff's attorney. That's why you have malpractice insurance. If you just give the patient some money, there's no guarantee he or she won't come back later and ask for some more. Plaintiff's attorneys generally know what they're doing. They negotiate for a living. If you don't want your insurance to pay for the patient's damages, that's something you should talk to your insurer about. You also don't want to agree to or offer to pay for a specialist services. Usually, you won't know if you committed malpractice. The patient has already sued you, so you aren't gaining much by keeping your insurer out of the loop. If you independently agree to pay for specialist services, your insurer is probably not going to pay for it. Also, very important, don't alter your records. An altered record is like a slam dunk for a plaintiff's attorney. An altered record is like an admission of guilt. If you do alter your records, the plaintiff's attorney will keep coming back to it and can be expected to bring it up in front of the jury for the purposes of discrediting all of your other documentation and your testimony. Also, don't lose your records. If you've been sued, get the record and a copy of the record somewhere safe. That includes the EHR. You also don't want to discuss the case with friends and colleagues. Discussion may be protected if done in a peer review process, but if you share anything outside of the peer review process, it's fair game for the plaintiff's attorney. Your discussions with your attorney are protected by the attorney-client privilege. You definitely do not want to admit guilt or fault, even if you're feeling guilty and at fault. Malpractice is specific, and there are a number of things that need to be proved in order for a patient to collect damages. There are ways to apologize and explain an adverse outcome without admitting guilt. Call your malpractice insurer for advice. They'll have documents on this, and they'll be able to coach you if necessary. Do not try to contact the plaintiff's attorney. Anything you say can and will be used against you. Attorneys advocate for their clients. It's part of our ethical code. You are not going to be able to talk the attorney for the patient into dropping the suit against you. Also, do not continue to treat the patient. Just make sure you go through the the dismissal process that we just talked about. It is unusual for patients to want to continue to treat with you once they sue you, but it's happened before. Just because you're volunteering doesn't mean you won't be sued. The potential malpractice risks associated with a dentist's participation in an access program, including Give Kids a Smile, are generally insurable under professional liability insurance policies. Allied dental employees or volunteer staff members working at the direction of the dentist are also typically insured. However, for specific information about your personal coverage, including any limitations or requirements, it's advisable to discuss your plans with your insurance agent or a company representative. There is also some limited immunity from liability available through federal and state law, but the applicability of the immunity will depend on the circumstances of your volunteer work. Make sure to talk to the volunteer organization, your liability insurer, and if necessary, your personal attorney. I've posted some information about volunteer dental care liability coverage in the Moodle folder for today's lecture. Okay, that's the end of this lecture. Thank you very much.